Thank you. Okay, now we'll turn over to talk about the umbrella rules, similar to the rules of civil procedure, with Judge Tierney.
Hi, welcome back, everyone. And it's a pleasant way to spend a Friday afternoon on a nice, beautiful day. And we'll try and get through this. So hopefully we can keep you entertained, because I know you're spending your valuable time. And again, with a beautiful day like this, I appreciate you being in here. So let's just begin with what we're calling the umbrella rules. And if you remember, as I mentioned earlier today, we really did try to create a process so that you could do an IPR on one day and then pick up a post-grant, a PGR, the next day. So what we've done is taken the statutes, and where there's common features on how we want to proceed, we've put them into what we're calling umbrella rules. So if you want to know how to conduct a proceeding, the conduct is usually found in the umbrella rules, and the more the differences between the proceedings are reflected in the case-specific rules that Judge Medley was just speaking about. So we're going to walk through some of these umbrella rules, which are pertinent to just about all the proceedings. There'll be a few caveats, but these are the rules you need to understand, kind of like the engine for all the different proceedings we're going to have. So let's just start off today. We're going to start off with something called real parties in interest, as Judge Medley talked about briefly. Real party in interest is a statutory requirement, especially in IPR, PGR, and CBM. So a petition will require a real party in interest to be put in. How are we going to handle real party in interest? As discussed earlier, we're going to have you basically put in the information that a district court would consider. We don't want to create any new rules that are inconsistent with the established practices. We're not trying to create specialized rules here where we have terms that are already known and understood by our federal court system. So we're trying to be consistent here with the way Congress has put it out, consistent with the way it's done in past practice. So if you're trying to understand what is a real party in interest, we've taken the liberty and in our practice guide, gone through how a district court looks at it, some of the considerations there. As Judge Medley mentioned, control, payment of fees, etc. Those are factors to be considered, but there's no one factor that is a bright line test. Also, we're going to have some additional information up front. The additional information, if you notice, this is in blue. So that means, again, for blue today, these are things that are not specifically required by statute. So what are the things that we thought were good to have up front in a petition, and what kind of additional information we're going to have from a patent owner preliminary response? Well, as you see, we do want to know your addresses. We want to know how to contact you. But additionally, we're also going to have things like, are there any related proceedings? I think as we've had questions today, there may be other court cases involving the patent. If there are, we'd like to know about it because, again, if a district court has, as mentioned during the break, if a district court has made a ruling that may affect our proceeding here, we need to be aware of it so we can take it into account. Obviously, the district court proceedings are putting a lot of time and effort into it. If they've made certain rulings on it, that would help us inform our decisions. Not that we have to adopt it, we have different standards. But again, these are things that we want to be aware of so that we can make the best possible decisions in our case. Also, another thing that we found extremely helpful at the board, lead and backup counsel. The reason is, as you're aware, we're all busy people. There are times when a lead attorney may be out of the country on business and unavailable during a certain time where a call is being made to the board, and we need to speak with somebody from the other side. So if one side's calling up and saying, we have a situation that needs to be taken care of today, and we call a party and their lead's not available, we want to know who to contact. And therefore, we have a backup counsel who can be there on the phone to handle these questions that may arise. Now that we've talked about counsel, let's talk about who may practice these proceedings. As you're aware, on these proceedings, we heard from a lot of different people. There was an issue about, we have general lawyers want to come in, we have patent practitioners want to come in, and both of them presented very strong, compelling arguments as to why they should be able to practice before the board. As you remember today, we said, what is a proceeding before the board? These new trials, are they ex parte or are they just litigation? And if you look at the way the statutes are set up, it's actually a little of both. There's an amendment process, something that patent practitioners are very familiar with. They do in, day out. What about the discovery provisions? Well, those are things that like a general litigator would do. So we had to step back and we took a look and we tried to find a balance. Remember, a key word in all these proceedings, we're trying to find the right balance here. So what we put out as a proposed rule, the proposal is a pro hoc vice. So this would allow a client who has that district court litigator, who's litigating on a certain patent, and they have all the information, they know how the district court litigation is going, they want that experience before the board so that they can coordinate efforts. Well, we wanted to be able to allow that client to have that lawyer before us. So we're allowing for a pro hoc vice motion where the person would come forward and say, I'm a general litigator, I have this many years experience, I know the patent in hand because I'm also litigating before the district court on it, so I have a lot of knowledge and experience. I'd like to come in before the board so that the client has the best interest represented and we don't have a disconnect between the proceedings. On those circumstances, we would take the pro hoc vice requirement and most likely grant it. Now, we've heard from the patent community that they had some concerns on the pro hoc vice requirement. They want to make sure, again, level playing field. How did they want the level playing field? They want to make sure that if a patent practitioner is subject to the office's code of professional responsibility, so would the general litigator. So we've taken that into account, and in our rule, we're setting up, we can go ahead and authorize pro hoc vice under such conditions as which the board may impose, with one of the conditions being imposed by would be the general litigator, the person pro hoc vice, would also have to abide by the office's code of professional responsibility. Again, a level playing field for all. Now, there was a concern, we listened to the public, there was a concern that, we don't know if this is true or not, but we want to make sure it's clear. There's a concern that certain general lawyers may come in and they may not may not follow the office's code of professional responsibility. That's not something we would hope would ever occur, but we just want to let the patent practitioners know, should something like that occur, the board is able to handle such situations because we will be able to have them brought before us. We'd have a hearing on it. We'd explain to them why they're not abiding by the office's code of professional responsibility and take the necessary action. Again, level playing field, rules apply equally to all. So again, we're trying to seek a balance here, so provide us your input on this. Now, we've talked about one hot button issue. We've also had a lot of comments about fees, so we wanted to have that up front. And just to let you know, we talked this morning, I remember, for the re-examination process, how they were doing their fee setting. Well, just a brief slide to remind people, there are two ways the office can do fee setting. The first, and that's one we're doing with our board rules today, is a 41D2 fee setting, which is a cost recovery. And it's not cost recovery for the entire office, but of the specific service being provided. So what you're seeing is our fees we're going to talk about are solely for the cost-specific recovery. If we provide the service in an IPR, that service is what we're recovering the cost for. Now, Section 10 is where the office can take a look at every fee, and it has to look at every fee in Section 10 fee setting, so they can set and maintain fees throughout the office, so that the aggregate is able to take in enough to be able to run the agency. I mean, that's a very general explanation. But the difference was 41D2, we can get that rule out in time of September 16th of this year, not very long from now, to be able to have it in place so these proceedings can go forward as Congress has requested. Section 10 was not going to be able to meet that deadline. So we will go forward in parallel and have a Section 10 fee setting on the board's fees. But it's not just board fees, but all fees in the agency. So if you have a question about cost recovery, that'll be for board rules. If you want to talk about fees in general, that would be your Section 10. Now, I just want to start here with a general overview. We're going to have some specific costs I'm going to show you in a moment, but I want to show you what we started with internally, give you some explanation of how we came up with fee setting. We looked at what is the average fee, what is the average cost for doing the inter-party review. Also, what is going to be the average cost for cost recovery for doing a post-grant review? And I have to step back and say, as internally, we were very pleased with how we went ahead and did this in the sense that having looked at inter-party reexamination, the current process we have in the office, if you look at the numbers, and they aren't quite as public, but the cost of the office for conducting an inter-party re-exam just before the examiner, and then you go to the board, because remember we're looking at beginning to end of the office, which is what these proceedings will do. They start with the board, end with board, and then the Fifth Circuit. Well, if you look at the cost internally for an inter-party reexamination from the day it starts all the way through the day the board rules and it goes up to Fed Circuit, you'll see that our costs in inter-party review are actually lower than inter-party re-exam. So by streamlining our processes, by converging the issues, we were able to get a process which is actually lower cost than the current process. And actually, the cost for PGR, I believe, is probably a touch higher than inter-party re-exam. So let's step back and see, what are we giving for our service here? Well, we're looking at 112, written description, enablement, and definiteness. We're also going to be looking at 101, and also 102, 103, public use and sale. We're looking at a lot more issues there. We're also, in addition, giving discovery. We know with discovery adds cost. There's lots of evidentiary objections. But still, even with all those additional issues, we've been able to target our costs to be close to what the current process is, which is a very limited review of this Patent Submitted Publications 102, 103 in the inter-party re-exam setting. So again, we're trying to streamline our proceedings to get these cases done. Now, we started off with the average fee. So let's see how we broke it out. We've broken it out, complexity, on average, increases with number of claims. At least that's what we find at the board. So let's say we step back and say, what number of claims do we typically see in a current process? So we went ahead and took a look at 3 months worth of inter-party re-examination requests. Now the numbers here, just to point out, if you start with the 40 requests had 20 claims or less, 40 out of 60, 20 claims or less. So 2/3 of inter-party re-exams or 20 or less claims. And that's with a system where it didn't matter how many claims were challenged for cost basis, it was all the same fee. Yet we go ahead and we look at the 21 to 30 claims, that would have 48 requests out of 60 were under 30. So 80% were under 30. And if we go up the line a little bit, you'll see the very near the bottom, sorry, it's near the bottom, but there was one request between 51 and 60, one between 61 and 70, and there was one outlier at 95. So if you look at the above 50, what you see is 3 cases out of 60. Only 5% of cases had the extensive claims of above 50, and only one was an outlier at 95. So we didn't even see a 100-claim case. And we had a meeting the other day among a lot of judges, and I asked, how many of you seen the 100-claim case? How many of you see the 200-claim case? We had one hand in the room that said, I've seen the 100-claim case, but that was just once. And no one raised their hand for the 200-claim case. These are the inter-party re-exams as requested. Remember, they can add a lot of claims during those if they choose to. But at least when the request came in, very few had the huge number of claims. So we said to ourselves, should we subsidize the large claim cases with the cases that are a little more simpler, people who are requesting only that which they need on the 20 or less? We said, no, let's try and break this out. So what we've done is proposed a fee set and a schedule where the party who comes in, remember, trying to converge the issues, streamline the proceeding. We've actually reduced the cost for the 20 claim set. Notice the cost for the 20 claim set is only $27,200. So that's below what we say is the average across all cases. Why have we broken it out this way? You can request an IPR on less than all the claims in a patent. As we talked earlier, your estoppel applies only against those claims in the review. So if you as a petitioner are doing the streamlining for us and come in and just challenge that which needs to be challenged, we're encouraging you to do so by bringing in only the 20 claim set that you might need a challenge. Now, again, if you need a challenge more, we understand there'll be circumstances. Well, those cases get more complex. There's more issues. A patent owner typically is not just adding claims above 20 because they feel like it. They're doing it because they have a business reason there. Similarly, if you're coming in and challenging more than 20 claims, you're doing it for a reason. That reason is pretty much there's a business reason behind it. Those cases tend to be more contentious. There's more issues involved, more claim constructions, more art, etc. So it gets a little more difficult, and we want to show we've had the fee schedule set so every set of 10 claims gets more costly to reflect the additional cost to the office in the service we're providing. And the fees do escalate once they get up above, I believe, about 60 claims. They really start escalating, and I'll talk about that in just a moment. and actually at the bottom of the slide I just want to point out, and that's where I was going. When we start seeing the 100-claim case, and again, internally we weren't seeing that. We know they exist, but that's the outlier. But if you have a 100-claim case, and you have to challenge all 100, and it may happen, what would be a good scenario to follow? Remember, we're going to talk about how to break things into pieces to try and resolve them easily, trying to manage a case and be expeditious, get it done in a year. Well, actually, you can break your case and file 2 petitions, not just the one 100-claim petition. You can file 2 50-claim petitions. And our theory here is this, and whether you agree with it or not, let us know. But what we're thinking here is, if I get it broken down into, say, 2 petitions, we all know that it tends to be discovery disputes. We also know that certain claim sets are going to be more valuable than others generally. Our hope is that if there's a claim set where the parties can settle, they would find a way to settle. Or maybe a patent owner doesn't feel like one claim set's necessary to go forward on, or it could be, there's business reasons that they could settle it out, make one case go away. Then we're not going to hold up the whole 100 claims until the end of the day. One of them can be resolved very expeditiously. Similarly, with discovery disputes and other disputes tend to be sometimes claim-specific. Like this set of claims goes to a certain invention. We're having trouble there. It may cause a delay. If you have just one case with 100 claims, then the delay on 5 claims or 10 claims or 20 claims delays the entire case. If you break it into its pieces, we might be able to get out the decision quickly and easily within the 9-month or 10-month range on those which are decided quickly, and only hold up that to the 12-month mark, or unfortunately, if we have to extend, again, we don't want to, we're only extending for the one claim set, the smaller claim set. So we're trying to get the resolution done in an expeditious manner. So that was our thinking on how the fees go up. Again, we look forward to comment on that. And I just want to point out, so post-grant review, we'll start at we're estimating 130 hours. If I go back a slide just a moment, we're estimating about 100 hours to do an inter-party review in the office if it's a case of 20 claims or less. Now, that 100 hours is an average where some of these cases are going to settle early, some will settle late. So 130 is just an average across all cases because we don't know in advance which one will settle, which one won't. Similarly, I'm going to turn over to the post-grant review. What we have here is we've estimated about 130 hours from the day the case is filed, because again, we don't know which ones will settle, which ones won't. But on average, across the board, about 130 hours of judge time. Now, I'm saying judge time because that's the primary driver of cost. I know we're taking a little moment here on fees, but let me spell out where the key areas are for the cost recovery. We have 3 key areas that we spend our time on. First is, we mentioned up front, we're going to institute claim by claim, ground by ground. We're going to spend the time up front to converge those issues. And that does take time. It's not, if we just had to find one claim to go forward on and then everything goes forward, it'd be very cost effective for the office. But unfortunately for the patent owner and also petitioner, it wouldn't give them the guidance as to how we're converging the issues. Instead, we'd just be letting all issues go forward. The next area we're going to spend additional time is for the hearing. Because at least in the past, we found that by walking into a hearing all prepared, we've had the judge go through the record, and this is how we do it. A first judge will go through the record, figuring out all the issues that they're spotting. So they're an issue spotter, point out the issues to converge them, what is important for the panel to know. And they point out identifying exhibits, legal issues. So when Judge 2 and 3, they're going to get a brief from Judge 1, which tells them, here's what I think you need to focus on. Now, Judges 2 and 3 have a target. They can also look at the entire record if they want, but it helps them at least focus a little bit better. Once we've gone through that process, all 3 judges walk in, and they know in advance, generally, what are the key issues we need to decide here. They ask the questions from which the parties are able to respond. If we walk into a hearing cold, it saves us time and effort, but then we're just sitting back and being receptive to whatever information, but that's not helping us really give the questions which are on our minds, which we're going to have to decide, and doesn't give the parties before us an opportunity to help clarify those issues in a way that we might understand them better. Because we have to, at the end of the day, decide these issues. By having a hearing, if there's something bothering us, then we know we can ask the question. It gives the party an opportunity to respond, or otherwise we might go into a final written decision with our understanding without that clarification to decide something, and the party goes, if only I had known, I could have clarified that point up front and not have this final written decision written this way. So we're going to spend time getting ready for hearing. And lastly, I think we all understand, a key driver of cost is we have to decide these cases. Internally, I'm just going to let you know, for an inter-party re-exam on appeal, we spend about 80 to 100 hours of time to make sure we get them right and write them up properly. And why is that? And we're going to spend the time here because these are very important cases. These obviously have a lot of money involved in them. We want to get them right. We know they're going to be taken up quite often in the federal circuit. If all we're writing up is a one-page, like almost a jury checkbox, claim patentable, claim not patentable, we're not giving the guidance to, one, the public, two, the parties, and three, the federal circuit when they review the case at the end of the day. So that's what some of our rationale was and how we came up with our cost recovery. I just thought it was best to have everyone understand it up front. Now, next point I want to go into is, as we mentioned earlier today, we defined the word petition as what you started proceeding with. This again, we're pointing out, how do you seek additional relief? We're calling it a motion, but really, basically, that can be as simple as a call to the judge. Remember, we're talking about streamlining the proceedings, and where we're spending time is the initial institution of the trial, the hearing, and at the end of the day. But it's very important to keep in mind, we will take the time. Generally, they're 15, 20-minute calls, which will short order will follow. But those calls are very important, and that's how or lower cost than the current process, inter-party re-exam. Now, in that process, the office went out with very detailed rules. You remember, if you practice inter-party re-exam, there's a lot of detail to them because they were trying to make it very defined. Unfortunately, because these are inter-party cases, I heard someone say, yeah, in inter-party re-exam, everyone's case is special. And when everyone's case is special, they seek relief from these rules. So with detailed rules, what happened is, instead of making it easier on the office, it actually had the converse. It caused what happened is a petition process where everyone is seeking relief because their case is special and they need to go and do something that wasn't anticipated, or maybe these rules are a little restrictive for what they're seeking to do. And in the end, what happened with inter-party re-exam, there were so many requests, and it's all paper requests, that there's some delay with deciding petitions because we get the petition, it's in writing, had to be written by the attorney, so the cost burden there. Then you usually get an opposition come in, and then even there's a reply. And these are issues which can be as simple as, we want 5 extra pages. You'll see a petition, spend 5 pages talking about why they need 5 pages, then an opposition spending 5 pages. So we want to just move things along. Remember, we're trying to streamline, converge these things. Let's just get on the phone. Both parties, of course. One side says I need 5 pages. Other side may oppose if they choose. And at the end of the day, you know if you're on the phone and your other party got 5 pages, you're probably going to ask for 5 pages too. And we want to balance things out. And so that's the way we're going to handle it. With the petition process, you only hear one side, then the opposition, the reply. We grant it there, then you get another, you generate another petition because, well, the other side got, so I need it. We're moving forward, streamline, having the call with the judges. So a party, now, again, I'm talking about opposition. I'm using terminology here just so everyone knows. A motion gets filed. Most of these are going to just be on the phone. Well, let's say a judge has, this is a complicated issue. It might be that you have another reason for unpatentability that had just come up unexpectedly. Something was found in a European practice. Party comes forward, says we need to have a motion on unpatentability. You don't want to decide those on the phone. Okay? So that's the kind of issue that we're going to have what we call the motion for, because we're going to do all the details there, all the supporting evidence. You're going to file, if you're opposing that, you're the patent owner, you'll file an opposition, to which there would be a reply. That's just terminology, so everyone understands what we're writing up in our rules. Now, let's say we're starting the case with our petition. Congress has informed us, and we agree completely, that certain types of information are going to be wanted to be kept confidential. So the general proposition here in the statute is all information is made public, except you may request that certain information be kept confidential. And the way Congress said we handle it is by a motion to seal. So what we've done is gone ahead and created a rule that essentially mimics a statute. We're allowing parties to move from motion to seal where they have confidential information. Now, what we want to try and do is encourage parties to only ask for information to be kept confidential where it's necessary. So if you can file a redacted copy, so it can be put into the public record, we're encouraging that. So therefore, what we have at the end of the day, once the case is over, if we've actually held something to be confidential, yet relied upon it, that information, the expectation would be it be made publicly available. So if you don't want the information made publicly available and you didn't need to put it in the case, put in a redacted copy. That way we serve the public interest, making it public, but also keep your confidential information confidential. We also provide for protective orders so that during discovery, when parties are going back exchanging information, they can keep the information protected so it's not just put out in public. Because we understand there are certain things that are trade secrets, et cetera, that the parties do want to maintain in confidence. And for that, I just want to point out, we do have a default protective order should the parties not agree. We've heard comments about that. If you have some comments, again, any of these rules, please provide us your comments. Now, we've already talked actually we talked, I think, in detail, but we're going to go out with a final written decision in 1 year. This is just a reminder again, as we talked about at the beginning of today, what are we trying to do? Make sure we can complete within the 1 year. But with the understanding we can extend for good cause should something unforeseen happen, something comes up basically, or some circumstance that necessitates us going past a year. That's not the general case though. In practice, we want to keep these to a year. If we have to go over, as Judge Medley meant, we may extend by a couple days here or a week there. We generally are not going to just be extending up to 6 months. So it'll be how much time would be needed. And again, that's the exception, not the rule. So how are we going to get to the 1 year mark? Well, if you read our practice guide, we go through and explain when we start these trials, we're going to put out what's called a scheduling order, which is going to tell you, here's how we envision the trial to be conducted and the times being set. We're going to have something called sequence discovery, where a party comes in. I'll go over that in a moment. Here we go. Let's say we're in an IPR, inter-party review. Generic case, well, how are we going to handle it? Well, we've already had 2 months for a patent owner preliminary response and up to 3 months for the board to decide the case. So at that point, we're at 2 to 5 months, Jen, 2 to 5 months. So 4 months after that 2 to 5 months, that's the point where we'll actually have the patent owner come in with their first full-blown response. They can provide all that testimonial evidence that they might not wanted to bring in early but didn't, or they can also bring in additional arguments that in the preliminary response they didn't necessarily put in because they wanted to see whether or not we even go forward. And at the 4 month mark, so you're really at the 6 months to 9 month mark. The important thing here to remember, and we'll talk about discovery, this will be after the patent owner has had a chance to do the cross-examination of the petitioner's witnesses. Because we want the patent owner to have as much information as possible when they file their amendment. So watch how we've done this. Petitioners only petitioning on those claims needing to be challenged. When we institute, we've only instituted on the claims which we find meet the threshold on the grounds that meet the threshold. So now the patent owner has a target, and they've been able to get the expert witness rebuttal evidence. They've cross-examined that expert witness, so they now know what exactly is the target, so they can put in their amendment and response. Subsequently, we will allow for petitioner to respond to that. We've given generally 2 months, plus they can respond to any amendment put in. They might not have seen these claims before because they're new claims, new terminology. Give the petitioner a chance to put in some additional evidence on these new issues that are arising. Followed by, we would give a patent owner then, if say there's new evidence or something comes up in a petitioner opposition to an amendment. Patent owner hadn't seen what the petitioner's come up with, so we put in a reply time for them also. After which, we're going to have time for having our evidentiary disputes to be finalized. As we know with discovery, quite often you hear that the expert's testimony is hearsay, it may lack foundation, etc. Well, let's get a defined set of what the true objections are and why. Also, we need to have a hearing from which we go to a final written decision. So that's a generic schedule. I'm going to point out next, how are we reducing burdens on the parties? We're laying out a framework which, again, streamline, converge. And how are we going to do that? One thing we're going to do, upfront, I mentioned, get only the claims challenged which need to be challenged. Also, if you're aware with inter-party re-exam, there's no page limit on the request. We've actually at the office received requests up to 10,000 pages. Now, if we get a request of that size, and that's putting a burden on patent owner to try and respond, this, as a judge, I ask myself, it's very hard for me to go through all 10,000 pages and understand every issue that's raised in 10,000 pages. Imagine how hard it is for a patent owner. We've also then seen the 1,000 pages So what we've tried to do here is we want to have a target. We want the patent owner to know why their claims are under dispute. Get that target created. So we have a page limit proposal. We basically, for inter-party review, have 50 pages in a petition. That's argument, 70 pages for post-grant review. Now, I use the word argument just briefly there, and I want you to focus on that. 50 pages of argument or 70 pages of argument. And why do I keep focused on the word argument? Because we're not limiting the type of evidence that comes in. You can submit the expert report that goes on for 50 pages or 100 pages if need be. If you have a journal article that goes on for 100 pages, that doesn't count to your 50. So again, we don't limit the type of evidence to support the issues that you've identified, the grounds you've identified. And there has been a question about claim charts and construction, and people are like, how can I fit in 50 pages of full construction for a claim? Well, let's step back and ask ourselves, how many terms are really in dispute when we look at the claims? A lot of claims are, well, they use the terminology the way it's ordinary meaning to one of our skill in the art. Well, if that's all the construction is, that's sufficient for our needs. What we want to have focused in argument, though, is the ones where you're saying the patent owner has done their own lexicography, they've used the term in a way that's ambiguous, et cetera, well, we know there's going to be a dispute. But if it's merely they've used it in a way that everyone understands, well, then your expert, who's a fact witness, can easily testify as a fact. I, as a person of ordinary skill in the art, have read this and understand the claim to mean the following because it's used in its normal fashion. And then cite 3, let's say, patents or journal articles, all supporting what that term means. But again, the focus here is get the target identified so the patent owner has the ability to respond. Now also, how are we going to reduce the burdens? We have these conference calls. I don't want to belabor the point. We don't spend a whole lot of time having these calls, but where we do, we find them to really keep the case moving. Rather than that petition, opposition, reply, which is another petition, opposition, that takes a lot of time and effort for the parties and the board. Let's get the calls, make the quick decisions where we can, keep the case moving forward. We have a 1-year time frame. So also, I mentioned one last thing. Again, issue by issue, claim by claim. Keep the eye on the ball. Keep it going forward on what needs to go forward. We mentioned that we're having testimony, as you're aware. We do have discovery in these proceedings. Now, in the statutes that basically set forth for IPR, PGR, and that would also cover CBM, cover business method, they define don't go greater than the following for their discovery provision. So for IPR, you'll see we've actually followed the statute very closely. For PGR, we had to balance interest out. But what did we do here? We backed up and said, rather than just create a generic rule for discovery, we need some discovery in almost every case. So we have what's called routine discovery, that which is pretty much going to be almost essentially in every typical case, you're going to have the following. So let's have that rule of routine discovery. That which goes beyond the routine now, we're going to call additional discovery. So what do we mean by routine discovery? Routine discovery, our goal here is to reduce the cost to the parties. They're making basic information available early. Because remember, we got to get these things done quickly. And what you find in discovery is if the information comes out late in the game, it can cause delay. So let's get that information up front. So what are we trying to do here? There's 3 types of routine discovery that we've identified. If you're citing a document, your expert's relying upon a document, you need to give it to the other side so that we all understand what's being relied upon. Not too controversial, just get it out early. Again, cross-examination for submitted testimony. If you're relying on an expert and you want us to credit that expert, you need to allow that expert to be cross-examined so that we can understand how credible or possibly not credible that expert really is. And lastly, I want to point out information that's inconsistent with the position. If you file a petition or a motion and you're advancing a position, which you're saying basically, this test works in this prior art. But you have 3 publicly available journal articles all saying they could not get the test to work. Rather than just hold on to that information saying, well, I'll just fight tooth and nail about whether it comes out in discovery, you need to file that information up front with us so the patent owner knows in that particular situation what the information is so they can formulate a response. But also, we know this kind of information comes out. We'd rather have it come out with the motion, with the petition, so that way the party who knows about this inconsistent information explains it away, as many cases they can do, but also gives the other side the information up front so we don't get late in the game to the 8-month mark and all of a sudden, surprise, here's some new information. Now what do we do with it? We can't afford to have that kind of delay. So let's get it out early. When you file a motion, if you have something inconsistent, bring it up forward with it, explain it away, and move on. Now, we talked about additional discovery. Beyond that routine discovery, we allow for what's called additional. Now, for IPR and derivation, it's going to be interest of justice. And IPR, we just follow the statute. They told us what's necessary in interest of justice is what you can go ahead and go no further. For PGR and CBM, there are a lot more issues involved. Remember that we had issues of public use, public sale, 112, et cetera. We wanted to go with a standard that wasn't quite as restrictive as interest of justice, but we can't replicate what's happened in district court, because if we're replicating district court, we're not the cheaper, more efficient alternative to district court. We are the district court. So we want to find the balance. And we heard comments from both sides. Some who wanted it as broad, some who wanted it more restrictive as interest of justice. We've gone down into a level of good cause standard. What does good cause mean? Let's just step back, and I'll tell you as one judge, this is not from a horn book, not from a treatise, but what's it mean to me is a good story. You explain, and the other party's going to be on the phone or in, however it comes up, a good story of why you need this additional information. If you can provide that, we can authorize additional discovery, and step back on the converse though. If you can't provide a good story as why you need the information, should we be authorizing that discovery? Because we heard today, I think a gentleman stood up and said, we need to keep in mind there are small businesses affected by this. So should we be authorizing discovery where there's no good story in those cases where it might cause a lot of cost and expense? So we went ahead with a good cause standard. Now that's lower than interest of justice, because if you say the words interest of justice, you can have a good story, but just a good story doesn't necessarily make out interest of justice. Necessary interest of justice, that's a fairly high standard. It's not ruling out the fact you have discovery, but that's something a little bit more than a good story. So we do have discovery, and Congress is aware, and most people are aware in litigation, what happens with discovery. It's unfortunate, but once in a while there is some abuse in discovery process, and it's pretty well documented. So Congress has provided the board with sanction authority. Now, hopefully we don't have to use this, but we all recognize that there may be situations that come up where the board may need to have a sanction. So the situations, abuse of discovery, abuse of process, harassment, again, we're hoping that we don't see these things occur. And if we do need to go out with a sanction, the sanctions range from the minimal, we can return a paper and just without prejudice to filing it with maybe the correct information, all the way up to including, this is a drastic, and we don't do this except in, it's basically we have no other option. We could enter a judgment or hold the claims patentable where there has been, for example, if it's clear that this is just harassment and there's no other explanation, the record's abundantly clear, it may be we would be needing to look at least consider the more stringent sanction. Again, we have a range here. We don't want to go out to the lower part of the range on the bottom of the slide, which is basically that judgment area. So the most sanctions are just going to be, we would hope to be minor, if at all. But let's say a situation occurred, abuse of discovery. Someone doesn't give the documents over, not letting their witness come forward. We may just basically say that witness will not be held credible. Their testimony won't be admitted because you didn't provide that witness for cross-examination. So moving along, we will have hearings. By statute, we'll have them. We're going to set them on case by case, because in advance, we don't want to go out and say every hearing before the board will take an hour. Every hearing will take 2 hours. In the abstract, it may be as simple as one claim at the end of the day that's involved with one issue. Fairly simple case possibly, or it even could be one claim, one issue, but it's a huge issue and we may need more time. So we're going to let the judge and the parties discuss it and set it on a case-by-case basis, taking into account the complexity. Now, the Congress has set forth that cases can settle, and they gave an incentive for a petitioner to settle. Where a petitioner settles a case with a patent owner, an IPR, PGR, and CBM, that terminates the proceeding with respect to the petitioner. So if there's no final written decision in a case and it's settled, the petitioner is not going to face the estoppel then from the final written decision because they're no longer a party in the case. So in a situation where it settles, the board can terminate the case completely with respect to the patent owner, or there's instances where we need to go forward for public interest. Congress has let us go forward. Again, that would be on case by case, but We do like having settlements where the parties are able to put in, say, X set of claims, which is patentable. And Congress has given us the ability to take in additional claims through an amendment where both parties are saying this puts a case of condition for allowance. So that's how the case could come about for settlement. Now, settlement for derivation, we're going to go ahead and accept the settlement unless it's inconsistent with the evidence already of record. Now, when we do have a final written decision, so the case doesn't settle, it goes up, we have the hearing, it goes to decision, well, it basically provides that there's going to be, let me follow the slide, we'll issue a final written decision in the IPR, PGR, and CBM. We're going to identify the claims, are they patentable or not. For derivation, we'll go ahead and say which claim subject matter goes to which inventor, okay? Who is a true inventor here? So that's a final written decision. It'll go into the details. We're going to write them in depth so that when they go out for public record, the public will understand what has occurred in this proceeding and also creates a record for appeal. And we all have heard earlier today, there are going to be some estoppel provisions. So if you're challenging a claim and it's in the review, in the trial, and let's say the case doesn't go your way, for those claims in IPR, PGR, and CBM, you would not then be able to come back before the office and have raised the same issues or those issues that reasonably could have been raised. Similarly, in district court or in ITC, you couldn't raise issues that reasonably could have been raised during the proceeding before the district court. For the IPR, PGR, and CBM is an exception, though. For covered business method, let's step back. You're charged or sued with infringement. So generally, you're already in district court litigation. So for CBM and CBM alone, they've said that when you go to district court and you have basically you're in district court and you come before the office, the estoppel will only be on that which was raised before the office. So it's a little bit different exception there on how the estoppels play out. Now, we have created something called patent owner estoppel, and let me explain why this occurs. Because we want the process, it's an inter-party process, and Congress has wanted parties to try and put in their amendment. They gave the option to amend. We didn't want a party being encouraged not to amend during the inter-party process by saying, I'm not going to file my amendment now because I don't want the petitioner to see my claims and possibly find art or arguments against me with their expert, and then go ahead and say after it, file an ex parte re-exam or through a continuation or divisional, put all their amendments in there. So we wanted, again, we're trying to get the issues resolved up in the proceeding at hand and not just delay having these amendments filed. So if you're already in the trial and you're a patent owner, you need to bring your amendments at that time. Otherwise, there is a patent owner estoppel. So bring your amendments in. Don't try and reserve all, and I'll just get a process. Also, derivation, be aware that there may be more than one invention involved. So where a party wins on one invention, loses on another for the claim subject matter, they're only going to be estopped on that which they lost and not which they won. As it was mentioned earlier, all our decisions are subject to rehearing. So if a judge puts out a decision that you believe misapprehends or overlooks something, feel free. You can contact the board. You just request rehearing. Rehearings are generally handled by a panel, so they can all look at what evidence may have been misapprehended, overlooked, or what argument. And in that case, let us know, because there are times when these are large records, something can get overlooked. So feel free, that's why we have these provisions there. Also, keep in mind, though, that if you're an IPR, PGR, CBM, how do you appeal? Let's say you don't prevail before the office, and you believe that there's an appealable issue, you go to the Federal Circuit. For derivation, however, they did provide that you can go to a civil action, which would be a district court action. So a little difference there. So with that, we now understand all the way up through appeal, and we'll have questions now. Thank you.
Yes, sir. We come to the podium to answer questions.
When there is a patentee's motion to amend, the petitioner can respond. In that response, is the petitioner allowed to raise new prior art, new grounds for invalidity, new issues essentially into the proceeding?
Yes, we would allow a party to bring in the new evidence because, in our opinion, they're probably going to be bringing in narrowed claims, obviously, but also patent owner may bring in new terms which were not previously considered. So we basically have a situation where an example would be a new terminology used, which has not ever been put into play. We would, of course, need to have evidence on that point by, say, the expert, or there may be new issues raised up on what is the effective filing date for that new claim, and there may be some issues about there's intervening prior art, et cetera, et cetera. So yes, we will take in additional evidence at that point.
Okay. And then my second question was, a party can't bring an inter-parties review more than 1 year after they've been subject of a civil action. So assuming a party has been sued with a patent before this law even passed, theoretically, they'd just never be able to bring an IPR on that patent, right?
Yes, that's correct.
Okay, thank you.
Other questions from our web or our live audience or comments? Please come forward to the microphone.
Thank you for your time. I just had a question related to a lot of the evidentiary issues that are going to get raised either through motion and limine. What is going to set the precedence for how those get decided? For example, expert under a Daubert standard for qualifications. Are you going to look to a certain district or circuit? It's going to be persuasive? Are you going to look to your own decisions as they continue to get made? Where would that precedent come from?
Well, the rules of evidence would apply.
Understood, but the circuits apply, Rule 702 a little differently. So what case law would the trial judge look to in order to establish like qualifications under Daubert? Or I don't know if that's been decided or not.
That generally, we're going to have to take I hate to say that we've generally looked at the issues. Commonly, we've looked toward Delaware, but I don't want to go out definitively saying we only look there. So it is an open question on how exactly. Hopefully, the circuits aren't too different, but where they have been, I personally looked a lot to Delaware in those instances. But I don't want to define it in bright line. It's something that maybe needs to be clarified.
And if you have a comment to that for a recommendation, you should consider submitting that during the comment period.
I understand. Also, kind of on a related note, then issues that get decided are your decisions from the patent trial and appeal board going to be precedent value for determining things like whether or not the threshold standard has been met for an IPR, PGR, sorry.
Well, certainly there might be, I think at first we would probably identify several precedential or informative type decisions so that we can let the public know, the sort of standards and things that we're looking at. So yes, I think that we would issue precedential or informative type decisions, especially at first.
Thank you.
Thank you.
Yes, sir. Please come forward to the microphone.
Ron Katznelson again. You mentioned that the determination of the real party in interest applies for some of those, but in fact it also applies under Section 115 related to an assignee who is then actually getting granted a patent. Under 115, current 115, patent is always granted to the inventor. An assignment is a separate arrangement between the inventor and the assignee, and the PTO had never had any involvement in that process. Under the AIA, however, you are now told to grant the patent to the real party of interest under 115 in a notice to the inventor. So where would you see a dispute on the issue of who the real party in interest is in the context of 115 coming into some of these proceedings, and do you have an idea where those disputes can be resolved under the PTO rules?
That's a question that I hadn't given a whole lot of thought. We don't see a huge amount of disputes in there, and typically where there is a dispute, those are more assignment disputes. contractual disputes?
There is no dispute today because no patent is granted to a real party in interest.
Well, actually, what we see, but again, the disputes we do see are where the inventor, on this going generalization, maybe let's say a professor, where they go off and make the invention, and then the university would say, no, that invention was made on your time while you're in the lab here, not your own time. Those are typically contractual disputes. So those typically happen in the district court proceedings.
Or in the state court.
Or in the state court. So the office generally doesn't get involved in contractual disputes. But for real party and interest, you can always go ahead and identify both if you want, or one. I mean, we just want to have an identification of who's the real party.
Will you apply, let me be a little more specific on this. Will you apply state court to these determinations of who real party and interest is? When there's a dispute of ownership, that now you have to make a determination on, because you're going to grant the patent. Who are you granting the patent to?
Let's see, what we're looking at is who's the real party and interest bringing a petition before us, right, to go ahead and go forward is where we identify the real party and interest.
I acknowledge that.
So in the situation where someone's bringing a petition, I'm not sure the 115 situation applies necessarily.
I appreciate that. And my question was, do you see where the rules of the office resolve the question of disputes in 115? That was my question.
Okay. On that, I'm going to defer over to the patents part because, again, for our proceedings are going to be brought by the third party. So in the third party, it's going to be a little different situation than 115.
Other questions or comments? Yes, sir.
I have a question pertaining to trade secrets and AIA. Do you have a form, and what is the maintenance to continue to keep a trade secret, let's say per se with a formula? And then if I need to answer that first, I had a two-part question. Is there a form or maintenance for to continue to keep a trade secret?
No. If an individual is interested in maintaining an idea as a trade secret, they absolutely should not fill out a form with the Patent Office revealing the trade secret.
In manufacturing process with employees, what is the recommendation for a trade secret for a manufacturer? Per se, as a reference, Coca-Cola has a formula. Coca-Cola uses a formula to that they might a trade secret, or Pepsi. Do they have to maintain a safe, an employee relationship as far as a non-disclosure? And at what point does that have to be considered, or does it have to be maintenanced by a practitioner or supervision of the means of manufacturing?
Well, this is a question that I'm not able to answer, specifically how an individual company what steps they should take to maintain a trade secret. The Patent Office really has nothing to do with trade secret protection. That's the responsibility of the individual company.
And then also on a trademark, can a trademark be three-dimensional and have shades or contour to it or shape? Or is it just considered a trademark has to be two-dimensional and then on, per se, a flat piece of paper?
Well, my understanding is that a trademark is limited to a word name or a design, and on the design front, I can't answer that question for you. I'm sorry.
Is a design, if a trademark has utilization to it but doesn't have a claim to it, and it just describes or shows the actual representation of the mark, the quality or the hallmark, can a trademark be other than two-dimensional?
Again, I'm sorry that I don't understand. I don't know the answer to your question. And we do have a question from the webcast audience. So to try to balance things out, I'm going to turn to that webcast question now. So the question is from our webcast audience, whether the office has ever considered using a representative type claim in one of these post-grant or inter-parties reviews for the purpose of trying to mitigate costs and keep the cost under the 20 base claim number.
Yes. That's a short answer. The long answer is we would like to have written comments on this. Here's what some of our thoughts were as we went through it. Again, the petitioner is the one who's going to come in with the request. The petitioner, if they're going ahead and identifying the representative claims, odds are, when we're thinking it through, the patent owner may not necessarily agree. And so then what we're going to have a situation is where the petitioners identify what they believe a representative number is. The patent owner has already paid for and filed their claims in addition to 20 and may have a different view, and which at that point we'd have to have a threshold determination, not as to which to go forward, but we're going to have to decide also, is it representative or is it not? And in essence, shifting the burden from the petitioner who's trying to narrow to the patent owner. It created an issue. We've thought about it. It also became an issue on how we would handle estoppel. It was a complicated question. It's something we could use guidance, and we look forward to comments on. But those are some of the issues that we're trying to balance out here. In the end of the day, we went with the scheme we have now, where the petitioner will identify the claims which need to be challenged, and that's what they will, effectively pay for. If it were representative, we were concerned they might just say, we're going to select, here's 100 claims. We'll potentially only select 3 as representatives, saying the rest go down. Patent owner would then respond with, no, they got to go claim by claim, in essence creating an issue, a pretty serious issue up front for whether we even go forward or not. And then if we went forward on the 3, it was a question of how we'd handle the estoppel. Are all claims in the case, in the review for estoppel purposes, or is it only the 3? At the end of the day, we went ahead with the scheme we have. But again, this is obviously a very interesting issue that we would like to have comments on, and we look forward to getting some.
Do you have other questions from our live audience? Yes, sir. Please come to the microphone.
One more question. I know that the petitioner is going to be having to put in proposed claim construction in their petition. In the written decision, is the board going to be issuing a claim construction for its case?
I don't think it's necessarily that we would. I mean, we might adopt the claim construction. I guess it would come out if the patent owner didn't agree with the claim construction. And then we would have to make a determination, broadest reasonable construction, how we would come out that way. So it may not be that it would ever be in there if it's not in dispute. Or it may be that we would if it were in dispute.
Has there been any thought on to how, like, a formally issued claim construction by the board would be handled by a district court?
How our claim construction will be handled by a district court? Since we have a different standard, it's unclear that it would adopt. They'd probably do as we do. They would take our claim construction into account and formulate their claim construction, and vice versa. We obviously take a lot of put a lot of consideration and effort into looking how a district court came up with theirs. But because we have different standards, it's not necessarily dispositive in either way. For ours, it's dispositive on theirs, or theirs on ours. But I do want to point out, and I make it clear, even where we go ahead with a threshold, we find a threshold's been met and go forward on the case, implicitly you could say adopting a claim construction by the petitioner. At that point, it's only preliminary claim construction. So we haven't had a full response by the patent owner with all the cross-examination and evidence. So the more definitive, it's basically a tentative claim construction at best up front, but we're also open to the response from the patent owner and their amendment to try and, at the end of the day, with the final written decision, have a more defined claim construction. Again, we're trying to define issues more and more, but on that we didn't want to come out and say this is the definitive claim construction before we had a full response by patent.
Yes, please come to the microphone.
In the spirit of filing multiple proceedings, because you want to not exceed the 20 claims, I'm coming and raising another question, a separate opportunity. The claim construction requirement in both in PGR and derivation seems to be a foreign concept in the proceedings at the Patent Office. Because you're applying the broadest reasonable interpretation, the claim construction, requesting that from the applicant or the parties is essentially an anathema to the process of the PRI within the office. You're not requesting it in ex parte communication today. It seems to me it's a burden on parties to construe the claim in a way that maybe a court would construe it in a proceeding that, in fact, is a negotiation on the claim, meaning the PRI is applied and the preponderance of evidence applied for that construction, for that determination. So it's not clear to me why you need the claim construction. I propose that you not request it. You already have the indistinguishable of the patentability submission requirements for indistinct claims, and you have the exchange that goes in the process of defining what the claims are through the BRI standard.
No, I'll just give you the rationale for why it was put in the proposal. And again, it's proposed rule. The reason we had it in the proposal is we want the petitioner to come forward and try and explain how they're construing the claim, so that therefore when we read the evidence in support of, say, unpatentability on prior art, we know what the target for the claim is and how that evidence should be applied to it. Not just for us to go forward, but also for a patent owner, so when they file a preliminary response, they know again what the target is. If there's no defined claim construction, then sometimes it's hard to match up the art with the claim, because we're left with this kind of vague notion. Is it really, how did they define the term such that this art reads upon it? So it helps everyone involved understand better what the playing field is the reason we put it up front. There's I think when you say there's not, implicitly there has to be a claim construction at some point, or else you can't apply the art against it. Because if you have no claim construction at all, and you have no idea what the claim means, then how could you ever say a claim's unpatentable over art? Right, so there has to be implicitly a claim construction. And actually, if you look at appeals from the board, where the board did not adopt an explicit claim construction, the Federal Circuit's recognized that implicit within the rejection itself is a claim construction. We're just trying to make explicit what is being implicitly done in current inter-party re-exam process, and in some cases is done explicitly.
We have a couple questions from our web audience. The question has to do with discovery, and you talked about two different types of standards for discovery: routine discovery and mandatory discovery that goes beyond routine discovery. So to obtain beyond routine discovery, what does a party need to do?
Well, again, the judge would be involved at this point. The parties would call, they would arrange a conference call with opposing counsel and the judge, and they would discuss or explain to the judge why the discovery is necessary. Interest of justice is one standard, or if he's got a good story. And then the judge will decide, is this an issue that we need to brief? What does opposing counsel think about this? So then we can go forward, either accept a brief or the motion to have the additional discovery, or we might be able to rule on the phone with respect to whether the additional discovery can come in at that point.
And then there's a follow-on question from our web audience that would like to know how the board is going to handle the exclusion of evidence. Will the board consider something akin to a motion in limine during the trial?
Well, we may. We do that now. Occasionally we'll consider motions in limine, but typically what happens is after the time for filing response and everybody's had their opportunity to take that cross-examination testimony, we have a period for we propose that we would have a period for filing motions to exclude evidence. And so at that point it would come in, and then the opposer would have an opportunity to oppose.
We have another question from our web audience regarding the scope of an oral hearing. When will the board will permit live testimony during an oral hearing?
Well, that would be generally the exception other than the rule. An exception may be where it's clear that one party's testimony is in particular interest to the board, such that it may be dispositive. And if it's the type of testimony that, let's just step back. As patent practitioner, I think you'll understand when we get expert testimony of a scientific expert, generally we can find through the cited materials whether or not their scientific basis is sound or not. You look at the underlying journal articles, patent publications, etc. There are some instances, though, where the credibility of an expert is such that, other than a fact witness, let's back up and say it's a credibility determination such as in derivation, where it may be the corroboration. The expert said, or the person says, I saw this, I was at the presentation, I saw the person talk from A to person B and tell them the invention. That could be a situation where we want to have that person, their credibility is such that we can't just look at the underlying journal articles and scientific basis. We'd want to almost have that person right there, seeing the person get cross-examined, because their testimony may be critical to the ultimate issue of did that communication occur. Again, that's more the exception than the rule. Most experts are going to be, in the case, technical experts, So that's what we're expecting by most testimony. There will be the exceptions where it's really, you need them there and see how they were answering the questions live to get a good sense of the credibility.
A different question from our web audience. Can a party file a summary judgment type motion?
A party can always at some point go ahead and request that the issues in the case are so well briefed that there's no need to go any further. Generally, these things are, because it's a contested case, there's almost always a question and material fact and dispute. So, but it's something we would entertain. Call a judge, let them know, and you can get a resolution. But again, most of these, just like in district court, are going to be heavily disputed, and I don't want to encourage people that these are going to be granted that often. These will be the exception rather than the rule.
I think I've had maybe one instance in 12 years where someone asked to do that. So it's rare, but it can happen, and I authorize that motion.
I do have questions or comments from our live audience. How about, yes, sir?
Hi, I'm Lowell Carson from Sandia National Labs. One thing that occurred to me as I was kind of listening and thinking here that I thought as a comment, when we're looking at the situation with someone coming in pro hoc vice to represent someone in the case, it seemed like you focused a lot on the Code of Professional Conduct as something you wanted to make sure was applied. Listening to some of the umbrella rules, particularly the discovery rules, they seem rather different. So, you know, perhaps there would be some sort of statement that they had read and were, you know, willing to comply with those rules as well, because you don't want someone 2/3 of the way through sort of doing something completely wrong because it's different from their standard practice.
Yes, that may be something that we would consider, and I know that we have done that in our current practice. On occasion, you have them come in with an affidavit explaining that, yes, they've reviewed the rules and they understand the proceedings, and then that way it sort of lets us know that, you know, they know what's involved.
Thank you.
Other questions, comments? Yes, please come to the microphone.
Darren Allen, and it's a three-part simple question, and it has to do with discovery, but then also with drawings. Obviously, a design patent is ornamental, so it has to require drawings. 2, a plant. Does a plant, can you have a picture, photothesis? It's non-productive, non-reproductive. Can you involve a picture? A grafting, do you have to show that the graft actually proceeded, or that in the farming community it's getting a little more than just ornamental and photothesis? And then 3, in a utility patent, goes back to chemistry, and with that, would the figure or the illustration have to have an actual drawing? And then where does the ghost, or maybe I'm confused, the ghost or the pirate of what an illustration of what it may go on to, but to mislead because it has to be publicized? Do you have to have drawings in a utility patent, and does that allow the examiner to reject it right away?
So for a design patent, that is the subject of the patent, so you must have a design. The claim is drawn to the design shown in this drawing.
How many are you allowed? 1 to 3, or 3 pages, and how many on a page?
Oh, I can't answer that detail of specifics. Minimum of 1, but how many, I don't know the answer. For a plant, no. And for a utility application, no. You do not have to have drawings. They are optional.
Okay. And then with packaging, do you have to have a drawing for packaging? Does that fall under a POP or a copyright?
I can't answer your question about packaging unless you're trying to patent some sort of packaging. If you're trying to patent some sort of packaging, you are not required to have drawings.
Oh, great. I appreciate that answer. I hope that's recorded. And then also for discovery, is that okay to ask? I'm sorry. I got pulled out because I didn't have a drawing. But anyways, I wanted to ask one other question. Am I allowed to submit a picture? Because it can't just have photothesis of an ornamental plant that's non-reproductive. Are you allowed to submit an actual picture so that you could show that through the cycle of the plant that you grafted or the tree or the bare root fruit, is there a representation that you have to prove that there was going to be an outcome?
I don't know the answer to that question either, but we have your name and we understand your question, so we can follow up with you at a later time. Okay, we do have a couple more questions from our web audience. This question relates to a topic we talked about this morning called supplemental examination, and the questioner would like to know whether if a specific patent is immunized from inequitable conduct through the process of a supplemental examination, does the immunization attach to any related application, such as a continuation or a CIP? The answer is no, it does not attach to one of those related applications. The immunization works on a patent-by-patent basis that is brought in for the supplemental. Now, the final question of the afternoon is going to come from our web audience, and the question has to do in the post-grant review or inter-parties review proceedings, is there an option for a declaratory judgment type action?
I think we just answered that, right? Or summary.
The question's on declaratory judgment?
Declaratory judgment, not summary judgment.
Well, I think here the question for a declaratory judgment, maybe I'm misunderstanding. Generally, a declaratory judgment is where the third party goes to district court and says the patent's unpatentable for the following reasons, or I'm not infringing, I want to find a holding of that. So in this instance, the filing of a petition is in essence taking the issue of patentability and bringing it before the office by the third party. So I would almost find that comparable to the declaratory judgment action for at least the issue of unpatentability. And maybe I'm misunderstanding something there, but that's how I'm perceiving it. So it wouldn't be the patent owner coming in trying to challenge their own patent because it has to be an inter-party proceeding.